Hi, Tim Blankenship here with Divorce661.com. In this episode, we're talking about when you do or should need to amend your petition and when you do not need to amend your petition. So I'll start by saying if you have a divorce case that you and your spouse are going to be coming to a written agreement on, in most cases, you're not going to need to amend your petition. For instance, I just got a new client and they started on their own. And by the time they sent me their documents, I noticed they had filed an amended petition. And I asked, why did you feel the need to amend your petition? Was there something wrong? Like, did you get a date of birth wrong or a date of marriage wrong or something significant like that? And the answer was no. And the reason they amended their petition is because they wanted to change the child custody from 50-50 to full custody. And my response to them was, the agreement that you ultimately come to in your divorce will supersede anything you write in the petition. So for this person, it was totally unnecessary to amend the petition because the child custody arrangement could have been decided in the agreement in the language we put forth in the child custody order. So in this case, that was not, it was not necessary to file an amended petition. And you want to be careful about filing amended petitions because you restart the clock on the 6 months. And what many people forget to do, as this person did forget to do, is when you amend your petition, you also have to amend the summons. And if there's children, you also have to file an amended UCCJEA. And I see this as a problem all the time where only the petition is being amended and they're not refiling the summons or the UCCJEA. And of course, the clerks are not going to tell you you're doing it wrong. And in this particular case, this client was told by the clerk that she did not need to file an amended summons, which is completely incorrect. So what are some cases where you will want to file an amended petition? I would say maybe one or two reasons. If you have the wrong date of marriage or wrong date of separation, or maybe you get a child's name spelled incorrectly or the date of birth on the child is wrong. If you made an error on that, you're going to want to amend your petition and the other forms so you can update with the court the correct names, because when you submit your judgment to the court, your final agreements to the court, the names have to match. So if there's an error on the petition, you will have to continue with the wrong names or wrong date of marriage or wrong date of birth on the judgment. You can't then, if it's Charles and you left off an S on the end for your son and it says Charles, your judgment's going to have to say Charles. You can't put Charles because they're going to say the name of the child does not match the petition. So that's one case you'd have to amend your petition. Another case you may have to amend your petition is when you think you're going to have an agreement, but then you have to you end up going to have what's called a true default case where the other party is not going to participate. Then you're going to have to amend your petition if there's assets and debts, because you will have to put forth a proposed judgment with your petition in that case. And to get a default case to go through, you have to list all the property on the petition through the property declaration. So word of the wise, don't amend your petition unless it is for one of those reasons that it really needs to be amended. Tim Blankenship, Divorce661.com. Hope you're having a great day. We'll talk to you soon.